my freedom because of what has happened, and it was all because of a dementia. And unfortunately, you can't control that, you know.
We have Mr. Harris in the prosecutor's office. We're here today for status conference. It's my understanding Mr. Newman's going to be entering a plea of guilty to 1 count of trespass and a habitation. Is that accurately stated?
Yes, Your Honor.
You're going to enter a plea of guilty to 1 count of trespass and a habitation. It's a 4th-degree felony, punishable by up to 18 months in prison and a $5,000 fine. If I did send you to prison, the maximum penalty also includes an optional period of post-release control, 2 years. Seems more likely, though, that I'm going to put you into my community control program. Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about July 13th of 2025 in Turtle Creek Township, Warren County, Ohio, Terry Dale Newman trespassed into another's home while a person was present, this being the home of Judy Ponder, who is 84 years old.
Anything on those facts, Mr. Newberger?
No, nothing on the facts?
Mr. Newman, did you hear those facts?
Oh, I'm
Yes,
sorry.
Your Honor.
Do you admit that they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. Instead, I am going to order level 2 pre-sentence investigation, and we'll see everybody back here in 8 weeks for sentencing. We also have an issue pending before the court on modification of Mr. Newman's bond. And essentially, I understand that, Mr. Newberger, we want to remove the monitor.
Yes, permission to speak? Your Honor?
Sure.
Briefly. He works as an auto mechanic. He's been on the GPS monitor since, I think, the beginning of August. I became his attorney August 29th. He's had no violations. I have no reason to believe that he would violate. And his time on the monitor was extended because we originally, Mr. Harris and I, overlooked the age of the victim, excluding Mr. Newman from ILC. So during that period of ILC assessment, he was still on the monitor, nothing further.
Mr. Harris, anything from the state?
Your Honor, based on the facts of this case, there is a concern. Obviously, one of the factors is protecting the public, and I guess giving peace of mind to the victim in this case. We would ask that the monitor remain on until at least sentencing in this matter.
So, Mr. Newman, I have a report from Officer Small at Community Corrections that said that you tested positive for cocaine today.
That's what it said, yes.
That doesn't seem consistent with your history at all. I also see that you tested positive for THC. That does seem consistent with your history. But we're going to send this test out for confirmation, and I'm not going to make any decision on releasing you from the monitor until I get the confirmation back.
Understood.
So if it turns out that you did test positive for cocaine, that's going to be a factor. If it turns out that you didn't, then I'm inclined to release you from the monitor between now and the time that we come back. We don't have to get together again for that. Officer Small is going to let me know when we get the confirmation back, and I will let you guys know what comes of that.
Thank you, Your Honor.
Thank you, Your Honor.
Take care.
All right, that's all. This is the case of the State of Ohio versus Terry Newman, case number 25CR 42874. Present before the court is the defendant, represented by Mr. Newberger. We have Mr. Harris in the prosecutor's office, Officer Niemeyer from probation. We are here today for sentencing. Everybody had the opportunity to review the PSI.
Yes, Your
Yes, Your
Honor.
Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
We have 15 days of jail time credit and no restitution. Is that right?
That's correct,
That's
Your Honor.
All right. Mr. Harris, on behalf of the
Your
state.
Honor, in review of the PSI, noted that he does have a history of alcohol and drug abuse. As we discussed in chambers, the facts of this case are concerning, and I'm not sure he has a understanding of the gravity of the situation that was created. My understanding is that these issues would be addressed somewhat through probation. I would ask that there be a no contact order with Judy Ponder, that he not be within her any area of her residence at this time, and in hopes that somehow he would understand. This might be new territory as far as the court's concerned. I haven't seen a history of this type of behavior. However, it is very concerning for the state.
Officer Niemeyer?
Nothing further, Your Honor.
Mr. Newberger?
Mr. Newman understands the gravity of this situation. I think he'll be an ideal candidate for community control. He also understands that whatever assessment, drug and alcohol assessment he gets, he will comply. This is his first felony conviction, and he's just turned 59 years old. Has no prior history similar to what these allegations are, and he understands he can't go back to the neighborhood or see the victim in this case, that there'll be a stay away order. Oh, and he asks that the EMD be removed.
Mr. Newman, what do you want to tell me?
Honestly, it's just the strangest situation I've ever been in. For 8 months, I would stop by her house. One day, I've been seeing a girl now for like the past 3 years, and she lives over on 123 in Lebanon. And she goes out and she picks at night, and she sells decent stuff online. So hanging out with her, I kind of figured out what she wanted and what she didn't want. And one day I was driving down the road, and I seen a toy box at the end of the driveway. And I stopped in, and the lady came out, and we started talking. I asked her if she was getting rid of it. And long story short, after then, for about 8 months, I stopped by about once a month to see how she's doing. I brought in wood for her. I helped her mow her lawn. I've even vacuumed her house for her. Unfortunately, I did notice that when I was stopping by that she couldn't remember my name. So I figured, she's probably getting dementia and stuff like that. And the day that the incident happened, I actually was there before the incident supposedly happened. And I asked her, she asked me what I did for a living, and I told her I was a mechanic again. She asked me if I could check the fluids on her car. And I said I could, but I had something to do. It would be okay if I come back by. She said fine. I said, well, I'm getting ready to take off. She even asked me, hey, could you hang out for a few more minutes? You're so easy to get along with, so easy to talk to. I said, yeah, sure. So I hung out for a few more minutes. Her neighbor stopped by just before I left and dropped some food off to her. And when he was dropping that off, I was getting up and I was getting ready to leave anyway. So I left and I came back, checked the fluids on her car. I knocked on her door like I always do. She opened the door for me, asked her for her keys. I went out, I started checking the fluids on her car. She came out, and I had her keys laying on the battery underneath the hood. And she picked her keys up, and I told her everything that was going on. And when I was done, I shut the hood and I followed her back inside. And then her neighbor came over and threw me out of the house. And so I left. I had no arguments, nothing. I just left, no big deal. And then the next day I was pulled over and found out that I had the warrant out for my arrest, which I had no clue what was even going on whatsoever. So, it kind of threw me for a loop. I meant no harm whatsoever to her at all. I'm not that type of person. Never have been. I'll help anybody in an instant. But now that this has happened, I've really reevaluated that. I've seen people that needs help, and it's made me gun shy. I won't help anybody anymore. It's got me to that point. I haven't been in trouble with the law in forever, ever. And this just slammed me, and I was like, wow. So yeah, it's really made me gun shy about helping anybody anymore. I've seen people broke down on the side of the road. I would stop. I got a pair of coveralls, and tools in my van. If I seen somebody broke down before this, I would stop and help them out. I don't do it anymore. I'm afraid for my personal freedom because of what has happened, and it was all because of a dementia. And unfortunately, you can't control that, But I'm not a bad person. I've made mistakes. I've owned up to my mistakes in life. I don't run from my responsibilities. I took care of my mom for 13 years, and nobody else in the family did. And then when she passed away, everybody took their share out of the house and left me in the cold. So I've been homeless for 3.5 years now, trying to get myself out of a $14,000 debt. I was halfway out, and then this hit me. Now I'm back down. I was $7,000 in the hole, and now I'm back to $14,000 again in the hole. But I got a good job. I've been working there for 3 years now. My boss loves me, and I just want to put this all behind me and get on with my life.
I think that, Mr. Newman, you and I can agree that this is a bizarre set of circumstances.
Yes.
And, I don't really know what to make of it, to be honest with you. But, I know that you pled guilty to the charge in the case, so, for you to plead guilty and you expect me to treat you as if you're innocent is not really realistic on your part. Also, the folks in probation, somebody who maintains that they didn't do anything wrong is a bit of a mixed bag for them because, first of all, They want to make sure that this kind of stuff doesn't happen anymore and address those issues. So I don't really know where this is headed. But the other thing is, you know, if you continue to be a law-abiding citizen, don't give me any problems, you're probably going to successfully complete your probation, so it may not matter either way. I'm going to place you into my community control program for a period of 3 years on basic supervision. I'm going to impose upon you the standard rules of supervision. Whatever the Talbert assessment says you got to do. I'm also going to have you complete the Court's Thinking for a Change program. You're going to have no contact whatsoever with Ms. Ponder or the residence in which this occurred. Stay away from it altogether. I'm going to remove you from electronic monitoring today, give you credit for the 15 days of jail that you have already done. I'm not going to impose a fine. I am going to impose the costs upon you. If you violate the terms of your supervision, Mr. Newman, or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 18 months in prison. Anything else we need to do? Anything I forgot?
Was there
Appellate rights.
was there an order as far as for drug and alcohol outpatient? Is that-
Yeah, whatever the Talbert assessment is, that's what he needs to do.
Okay.
All right, finally, Mr. Newman, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they'll all be provided to you at no charge. Good luck to you.
Thank you, Your Honor.
Thanks, sir.
From the prosecutor's office and Officer Rose from probation. We're here today for a final violation hearing. Mr. Newberger, does your client wish to have a contested hearing in
No,
this
he
matter?
admits, Your Honor.
Mr. Newman, do you understand the rights you're giving up by admitting to this violation?
Yes, sir.
Is this what you want to do?
Yes, sir.
Do you admit or do you deny that you violated the terms of your supervision?
I did admit it.
Based upon your admission, I find you have violated the terms of community control. We have 38 days of jail time credit. Mr. Harris, anything from the state or on behalf of the victim?
Yes, Your Honor. In regard to these allegations and the violations, there is a concern after speaking with probation that the defendant lacks insight into his issues. I know that we came into this previously with the idea to do an evaluation and see if he could go into a treatment facility, which I think that he is in need of. However, the state and I believe probation feels he lacks insight into his issues. And therefore, we would ask for a period of incarceration.
Officer Rose, what's your take on all of this?
Your Honor, I agree that the STAR program could be beneficial for Mr. Newman. He does really well in a structured setting. It's when he's back in the community that he has issues, and he states that he does not see a problem with using, say, cocaine when it comes to having migraines, and it's a consistent battle when he's in the community, and so my concern is he would get out and we would have the same exact behaviors.
Mr. Newberger?
I don't think we have a clue as to what he'll do when he gets out, if he really goes into a CBCF, where he gets the treatment and he can bring up his migraines and get treatment for his addiction, which he does admit. And I'd let him speak with you about whether or not his mindset is that he might be better off going to a lockdown treatment facility where he can get help with a long-term addiction problem. And not worry about his van. His van is with his boss. If his boss still hires him back when he gets out of treatment and if he's cleaned up, it might be better for everyone, including the county of Warren and the state of Ohio.
Word in this, what do you want to tell me?
Your Honor, I tell you right now that my migraines just have gone. I haven't had a headache in over 21 days. I rededicated myself back to the Lord and asked him to take my pain away, and he did. Surprisingly enough, I mean, I'm surprised myself. I do admit that I messed up. I'm disappointed in myself. I'm disappointed that I let everyone down the court system, my boss, myself, my family. I would go ahead and, if you can put me into a program, I can guarantee you right now that you won't have any kind of issues with me whatsoever. And when I get out, I have no desire to even smoke marijuana, do coke, or anything anymore.
All right, well, I'm going to continue you on community control. I'm going to order that you enter into and successfully complete a community-based corrections facility. STAR seems like a good option. It's a 4 to 6 month inpatient program. And when you get out, you will be on 60 days of electronically monitored house arrest. But I'll let you go to work if you get your job back. I think that probably makes sense. Get a smooth transition back. And hopefully, Mr. Newman, you'll pick up the tools that you need while you're in the STAR program, so that there is no more of this nonsense, I mean, I agree with Mr. Newberger. We don't know what's going to happen when you get out, but you need to do better.
I will.
All right, anything else?
No.
All right, that's all. Good luck to you, Mr. Newman.
Good luck to you.
Thank you, sir. Thank you.
The proceedings in the state of Ohio versus Eric Cox captured two connected court moments in the same case. First, the original sentencing for a serious repeat OVI offense, and later the hearing on Cox's motion for judicial release. Taken together, the transcript showed a defendant with an extensive drunk driving history, a judge who viewed the case as extremely serious because of the danger to the public, and a defense that tried to frame Cox's conduct through the lens of alcoholism, newly diagnosed bipolar disorder, and the possibility that proper treatment might finally break a decades-long cycle of reckless behavior. At the original sentencing hearing, the court called the case a state of Ohio versus Eric Cox, with Cox present alongside his attorney, Mr. Perry, while the state was represented by Ms. Tranter. The prosecutor made clear at the outset that the state wanted a prison sentence. She described the offense as a serious public safety matter and stressed that this was Cox's 7th overall OVI. She also noted that Cox had 13 days of jail time credit and argued that his driving privileges should be taken away permanently. The prosecutor emphasized that Cox had no regard for the law because he was already driving under an OVI suspension when he committed this newest offense. In the state's view, that fact alone showed that lesser sanctions had not worked and that a lifetime driver's license suspension was appropriate, along with a meaningful prison sentence. The probation department then weighed in and recommended prison as well, though with the possibility of judicial release later. That recommendation foreshadowed what the judge would eventually do, but at this stage the focus remained on how to punish Cox for what everyone in the courtroom recognized as an extremely dangerous repeat offense. Defense counsel did not pretend that prison was unlikely. In fact, he openly acknowledged that the court was going to punish Eric Cox and that prison was very likely. Still, he urged the judge to temper the punishment and to consider something he believed changed the way the court should understand Cox's history. Counsel explained that if Cox had a choice between local jail time, a CBCF, or the Department of Corrections, he would actually prefer prison because it would allow him to continue receiving his bipolar medication, specifically lithium. Counsel then introduced what he believed was a major turning point in Cox's life, a diagnosis made in June at Recovery Refined. According to counsel, for the last 25 years Cox had been treated for chronic depression with antidepressant medications, but those medications had actually aggravated an underlying bipolar disorder that had gone undiagnosed until the summer. Counsel argued that this new diagnosis mattered because it could explain a pattern of behavior that had never been properly addressed. In his telling, Cox's life had been shaped not just by alcoholism but by untreated bipolar disorder, particularly hypermanic episodes that led him to believe he could do things he plainly should not do and still pushed him into risky behavior. The hope now, counsel said, was that with lithium and proper treatment, those highs would disappear and Cox could become the person he had always tried to be. He emphasized that Cox was absolutely 100% compliant with the medications his doctors had recommended, and that he also fully understood he was an alcoholic. If he started drinking, counsel explained, he would not merely use alcohol casually but would abuse it until it triggered what counsel called an alcoholic rage, and then crazy things happened. The defense was not asking the court to ignore the offense. Rather, it was asking for mercy and some temperance in the sentence so that the future Cox now hoped for, one built on proper mental health treatment and sobriety, could be realized sooner rather than later. Counsel also tried to humanize Cox by pointing to the life he still had outside of court. He told the judge that Cox was supported in the courtroom by his mother and his fiancée, and that he owned a successful painting business. These were not minor details in the defense's presentation. The point was that Cox had something to lose, that he was not simply drifting without anchors, and that a sentence that allowed him to come out sooner rather than later would preserve the possibility of rebuilding that life rather than destroying it completely. But the defense also knew the reality of the case. Counsel did not minimize the fact that Cox had a serious problem or that punishment was warranted. He instead tried to place that punishment inside a framework of hope. If the court imposed a sentence but left open the possibility of judicial release after Cox served enough time to get his attention, then the court could still protect the public, punish the offense, and give treatment a chance to wake. When the judge asked Cox whether he wanted to speak before sentencing, Cox's statement was direct, remorseful, and strikingly accepting of the punishment he expected to receive. He said simply that he was sorry, really sorry, and that he accepted accountability. He told the court he was ready to serve his sentence as a man and that he realized he deserved to be punished. He acknowledged that even his own lawyer had told him in the past that he had received relatively light sentences, and Cox admitted that he did not disagree with that assessment. He said he knew the judge was likely to be harsher this time and wanted the judge to know that he accepted that and believed he deserved it. Cox apologized for putting the court and everyone else in that position, insisting that this was not the person he wanted to be or the person he believed he really was. He then returned to the point his lawyer had raised, saying that one thing that gave him a sense of hope was anew.